Hello Internet, thanks for tuning in to this podcast. If you're enjoying this channel, the best thing you can do is like, subscribe, comment and share. That's how the channel will grow and that's how we can get on even bigger and better guests. Before we get started, I've just got a few short messages. First off, the first round of crowdfunding for my book has now come to an end. Thanks to everyone that contributed. But I still have about 12 or 13 spaces left for names in the acknowledgements. So if you want to pre-order the book and get your name in there as part of telling the wonderful story of the GameStop saga, you'll find links to pre-order the book in the description below. Next up, I have a few sponsors for the show today. Your internet browsing data is on show for governments, ISPs, or bad actors to see when you fail to use a VPN to protect yourself. So why not try ExpressVPN, the internet's #1 VPN? You can protect your browsing data from your internet provider and prying eyes by going to ExpressVPN today and getting 35% off 12 months of ExpressVPN. Use it for privacy, safety, or just to watch Netflix shows from another part of the world. You'll be stunned at the amount of extra content you can access just by setting your location to somewhere new. Next up, I have a wonderful podcast to tell you about, but no, it's not this one. Rico and the Man is a New Jersey meets California no-holds-barred podcast about the entertainment industry, where former college buddies Rob Traegler and Peter Martino both slaughter and praise Hollywood and the film industry. The two bounce really well off of each other, sliding effortlessly between childish banter and in-depth commentary and analysis. For listeners who love Kenny G, one of the latest episodes, Spider-Man: No Way to the Toilet, not only contains one of the funniest and most wide-ranging discussions of the highly anticipated new Spider-Man film, why does Doctor Strange seem so off in the trailer, will Tobey Maguire cameo in the film, and why the sheer number of other superhero films allows filmmakers to be more creative in the modern day. But it also includes music from saxophone legend Kenny G, not to be confused with the hedge fund manager that Twitter was calling for the arrest of. #Ken Griffin lied. Rico and the Man covers the latest entertainment news while keeping a firm foot in the Hollywood that was. With special guests, best of lists, trivia, and an attempt at comedy, Rico and the Man is the perfect distraction for your pesky priorities. You'll find links for everything in the description below. Anyway, here's the podcast. Is that working? I think we're live. Well, someone can tell me if it's not working. But hello everyone, welcome to another episode of Chatter. Today I have the pleasure of being here with the lawyer of the apes. Welcome to the show.
Thanks, Josh. Thanks for having me.
Yeah, no problem. It's an absolute pleasure to get to chat to you. Do you want to, before we start then, do you want to give people an idea of what your background is, just so they know who you are? Yeah.
Sure, no problem. So as my name suggests, I am a lawyer. And since this is the internet, I have to say that, yes, I am a lawyer in real life. That is not just a moniker that I'm using on Twitter. I am an actual admitted attorney. I've been admitted to practice law for now, I'm getting old, since 2005. I had to even think about that. I'm not, I'm on the older side, I guess, of some of the apes in the ape community, being a 40-year-old, but I guess I'm not a boomer. But yeah, I've been practicing law for a while. I've done a lot of litigation work and appellate work over the years. I have not done anything in regards to SEC law. The SEC is a very narrow, they're an organization that is, set up to be more of an administrative agency. So those types of cases are usually handled, by administrative offices and internally with administrative attorneys. And sometimes that stuff gets taken up to the courts, but not really. That's usually dealt with by the organization internally. So a lot of the stuff that you're seeing now is more in relation to breach of contract actions, antitrust, negligence and stuff like that, which is in areas of the law that I have been familiar with. I've done multi-district litigation, which is what is called an MDL, which is different than a class action. Those are two different things. People need, get confused with those. The MDL that's currently pending in federal court for the short squeeze litigation, an MDL is a situation basically where the cases are all very similar, but each person suffered an injury that's different. So and in a class action, usually everybody had a very similar injury. So in a class action, the group would all be under one banner. And then no matter what happens in the case, there would only be one decision. So once it's decided that the case is a winner, then those plaintiffs would all split the money mostly equally. And a lot of the times you'll see it where you'll even receive these cards in the mail that say, oh, become part of the class action. And, you participated in, there was a big one a couple of years back with Live Nation, a ticket company. And they had done something erroneous, and they had sent a letter out to anybody who ever purchased a ticket through this company. And they said, you can be part of the settlement, just sign this paper and you could be part of it. And a couple of weeks later, they sent me a $5 voucher. And then what it usually happens is there's such a huge class of people that the money gets divided up over so many people that nobody ever actually makes any money except the lawyers. But with the multi-district litigation, it's completely, and if you lose the case, then everybody loses, the entire class. But in multi-district litigation, it's a little bit different. Each individual, there's what's called bellwether cases. Those are test cases that are done in the very beginning of the litigation process. Now, this is after it survives the motions to dismiss and the motions for summary judgment. This is when you're really getting far into the litigation at this point. So basically, they create what's called a master summons. So everybody from all across the nations, let's say they were, affected by the short squeeze, they would submit they would get a lawyer, hire a lawyer, and then the lawyer would basically fill out this master summons, no matter what state they're in, and it would all get put into this multi-district litigation that's currently pending in Florida. But the interesting thing is, each individual case is treated on their own. So if one is a loser, then there's a potential for you to become a winner. Your case stands on its own. It's common in theme, but each case is fact specific. So the MDL model, in my opinion, is the stronger model, because then when it even comes time for potential settlement talks, what they do is they create what's called a grid. And the grid basically says, okay, do you fit in box A, B, and C? Yes. Okay, well, you're going to get X amount of dollars. Do you only fit in B and C? Then you get X amount of dollars. Oh, you're only level C. You're going to get, whereas in the class action, everything is divided pretty much equally, and nobody usually gets a good amount of money. In the MDL structure, your case is treated and looked at individually, and it's based upon your losses. So if you had lost $5,000, you could try to settle for, $3,000, just to move the case along. Most of these multi-district litigations, they don't go to verdict. They are, they drag out for years. That there's no doubt about that. If this survives the motion to dismiss, this is not going to be, decided within the next year and a half. You're looking at least at a minimum, I'd say, 3 to 5 years.
Okay.
They will drag this out forever. That's the key to litigation and mass tort. You want to delay it as long as possible. You really see this more in, like I said, the context of negligence, and it happens a lot with defective drugs, and where a group of people took a certain medication, and then because of that medication they get cancer, and then basically you file these MDLs. Each one had a different type of cancer. Some survived, some unfortunately passed away. So at the time of the settlement, the person who passed away may get more than the person who survived. And it just depends on the type of injury. But again, this is not something that happens overnight. These things take years and years and years to get resolved. And I would imagine that in the context of antitrust, it would take just as long. You know, unless there's a huge, you know, look, this is getting a lot more media attention in the United States than, you know, even the mass tort drug cases get. You know, you never see too many people clamoring on Twitter about this, but this happens all the time. There's tons of medications that are causing, you know, serious injuries to people, but you rarely hear about it. You hear about it at the end when there's a settlement. Maybe you hear, oh, $5 billion settlement by XYZ drug company. But like, wow, that's interesting. But, you know, you don't, this is something you hear every day on the internet. So that might lead to some pressure, and that might lead to a faster settlement potentially. But again, you know, most lawyers are going to delay. That's the name of the game, unfortunately.
Okay, so right.
So that's my background, basically. I've done a little bit of everything over my career, and now, you know, I've moved up to the point where I have a position where I don't litigate anymore. I actually decide cases. So I'm actually, you know, I'm at a different point in my career. I don't litigate anymore. I did it for many years, and it was fun. And now I have a little bit of an easier job.
Yeah. I mean, that's not well. You sounds like you've put in the hard work. So basically, yeah. So I wanna just today go through this lawsuit against Citadel and Robinhood and sort of get as good an understanding as I am capable of coaxing from you as possible to try and help both myself and other people understand like what this lawsuit is, what it looks like, and how it could affect different things, how it could influence the situation and what the likely outcome is. So first off, actually, now that you've mentioned these MDL cases, is it a class action lawsuit that we're looking at here against Citadel? Because that's how I've seen it described, but now I'm not sure if that's been poorly worded. Now that you've mentioned that there's a difference between these two types of like multi plaintiff cases.
Right. So in this, what happened was there were two. But this was up to the lawyers. They're the ones who decided how to file this. So basically, it was filed. There are currently two complaints. One is an antitrust complaint, and the antitrust complaint is against Robinhood, Citadel, and all the other brokerages that were involved in the short squeeze litigation that, you know, from what took place in January, in regards to the limitations and the taking away of the buy button. That was filed as an MDL.
Okay. That
is filed as a multi-district litigation, which is the preferable, in my opinion, methodology. There was another complaint that was filed against just Robinhood for negligence, gross negligence, breach of fiduciary duty, and a number of other counts. And that was filed as a class action. Now, that's a litigation strategy. That was up to the lawyers. You know, I'm not going to second guess why they did that. But me as a lawyer, I think that the clients benefit the most through MDL litigation, because, like I said, it's more case specific, and you have a class action is all or nothing. If that main case is dismissed, it's dismissed against everybody. Now, in the MDL, this initial motion to dismiss is to dismiss the initial complaint. And right now, there's only 4 or 5 plaintiffs named in that complaint. If they survive this motion to dismiss, then a bunch of other people can then start. They'll have what's called a form. It's like a form summons. It'll just be available to download, the lawyers, and they'll be able to fill it out, and they'll be able to send it to their clients. So basically, the MDL structure is different, like I said, than the class action structure. But yeah, so there's two. So that's the difference. One's MDL and one is class action.
So the one I'm most interested in is the antitrust suit. That's the one that I feel has I don't know. I feel like that's more significant in this case, just because of what it's alleging. So, on what grounds have they filed an antitrust lawsuit here? Like, what is the basis of their case?
Okay, so basically, it's only one count. in the plaintiff's complaint, and it's a violation of the Sherman Act. So the Sherman Act basically says the legal. I mean, if you read the actual Sherman Act itself, it's this ridiculously worded statute. It basically says, though, in layman's terms, that there's a conspiracy that unreasonably restrains trade. So do you want me to break down like what each of those things mean?
Yeah, please.
All right. So a conspiracy, that's the first part, right? So what's a conspiracy? Well, the word conspiracy gets thrown around on the internet so much, and it was funny. Citadel was calling all the plaintiffs' lawyers conspiracy theorists, which made me laugh because, people on the internet, they might be saying, wait, they're calling us conspiracy theorists, but they're being alleged to have committed a conspiracy. So what's the difference between the two? I think the term conspiracy is used so loosely nowadays to describe anybody's opinion you disagree with that, I think when people hear the word conspiracy in the lawsuit, there might be some confusion. So conspiracy is an actual legal cause of action, right? And a conspiracy involves an agreement. There has to be an agreement, right? There has to be an agreement between one or more people. These people get together, and it happens most commonly in price fixing situations, right? So basically, two people that own a business get together, and they basically say, listen, I've got an idea. We can do this where we can, fix the prices and eliminate our competitors. And what do you think? You think we should do it? And the other guy says, yeah, let's do it. And then that limits trade, that restricts the ability for there to be a free market economics. And that is the very basic explanation of what a conspiracy is. It's an agreement between two people to basically, screw somebody else, for lack of a better word. But that's the layman. That's not a legal term of art. That's the layman term. I mean, that's basically it in a nutshell. Yeah. I apologize if your show's PG.
No, it's not. Don't worry.
Yeah. Okay. But yeah, so that's basically what a conspiracy is, and that's what they, are alleging as their in their complaint.
Okay, right. Before we go further, I'm just gonna pause you there because there's some mad thing happening outside. I'm just gonna shut the window here very, very, very quickly.
Oh, sure, no problem.
It's always the way, you'll start a stream and a conversation and there'll have been no noise until you actually begin recording or streaming, and then everyone decides it's party time.
Of course. I was just dealing with the same thing. One of my kids came in here tiptoeing, but the tiptoeing was like blah 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 thud 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 thud. It's like, they're trying to be quiet, but they actually wind up being more noisy than they intended.
Yeah. I mean, that's also the other issue. So, so the allegation here that we're discussing in this antitrust suit is that there has been conspiracy to limit and restrict trading. So, do you know what the legal definition is here? Do you know what the legalese is for it? What they're attempting to suggest is ridiculous? What the thing that they're trying to say they definitely didn't do is?
Well, I mean the legalese is that conspiracy to commit, X, Y, and Z price fixing. I mean that's the legalese. What's going on here is this. Okay, so here's the allegations in a nutshell, right? Robinhood took away the buy button, right? They said you're not allowed to buy AMC, you're not allowed to buy GME, you're not allowed to buy COS, you're not allowed to buy a number of ticker symbols. And their allegation is, their defense, I should say, is, well, we had a $3 billion, amount of money that we had to pay. We couldn't do it. So we had no choice but to do this. But the plaintiff's allegation is, that's not really what happened. What happened was this. You and Citadel conspired to take money away from retail investors. Okay, so the defense argument is that's not plausible, because under the most controlling case which is Bell Atlantic versus Twombly. That's the leading Supreme Court case. That case basically said, if you're going to allege a conspiracy, you have to show that it was plausible, that there's a plot, that your theory of conspiracy is more plausible than their explanation for why they did what they did. So Robinhood is saying, listen, we didn't do this because of any nefarious scheme. We did this because our backs were against the wall. So this is a plausible explanation for why we did what we did. Plaintiffs say, not so fast. It's not a plausible explanation because, Robinhood, this is not the first time something like this has ever happened. Companies have short squeezed, there's been short squeezes before. There's been volatility in markets before. And you can't say, oh, well, we weren't aware, we didn't have enough money in the accounts. That's our bad. We didn't mean for that to happen. Their argument is, no, that's not what happened. What happened was Citadel and you got together. This was happening. And Citadel basically said, this is allegation. Nothing's been proven. Citadel basically said, Robinhood, listen, we have a ton of short positions. This is killing us. Can you do us a favor? Yeah. Let's take away the buy button. Yes, we understand it's going to make you look like you have egg on your face and you're probably going to lose a bunch of customers. But the reality is, and as alleged in the complaint, we're paying you millions and millions of dollars a year in PFOF. So if you lose us, if we lose all of our money and we go belly up, who's going to pay you? We're your biggest influx of cash. We know you have other companies, other companies that will pay you, but we're the biggest fish in the pond. We're your golden goose. So if you lose us, you're going to lose everything, basically. So that's the allegation, that they were all there. There was an agreement, and they were all in on it together. And they basically said, "Listen, you scratch my back, I'll scratch yours. If you want things to keep going the way they are, then you're gonna make this happen."
Yeah, so that's basically that's it in a nutshell. It's like really well summed up. So there's a few things that I wanna note here is that first of all, to suggest that Robinhood would be not under pressure for this is to suggest that there isn't a lot of their revenue coming from payment for order flow. So first off, they had in 2020, 75% of their payment for order flow came from 75% of their revenue came from payment for order flow, and 81% of their revenue in the first 3 months to March 2021 came for payment for order flow. That's $331 million, an increase of $91 million from the same period the previous year. So this is not an insignificant amount of money that has been that they're talking about here. It's not something that is inconsequential, shall we say, to their business model. So the other thing that I want to note is that the allegation that Robinhood have made is that they were forced, because I've listened to the explanations in the hearing and what Vlad Tenev had said to Elon Musk when they did like a clubhouse together. So essentially they got the call in the middle of the night, or they got an email at like 3 o'clock in the morning, and they said, hey, you have to post this extra $3 billion or you can't trade, basically. Like we're not going to support you as a broker through our clearinghouse. So the NSCC, they then negotiated down to 1.4 billion, not 0.7 billion, so $700 million. And then Robinhood were like, okay, we can afford that. That's not the same size as like the market capitalization of our entire company. We can afford to pay that. And they said that they had negotiated with the NSCC that said they would decide to restrict the buying of some stocks and shares to reduce their exposure to massive volatility, because that was the reason that the VAR requirement, like by the NSCC, was $3 billion, was it was worked out on their formula, and it came in at 3 billion. And then the thing that is really interesting to me is like the key to this case is that the DTCC, the head of the DTCC, has said that they waived all capital. The NSCC had waived all capital requirements from that day through to the end of that week. It seems to me at least like someone is lying. And I guess the how would you go about trying to prove this in court? Like, where would you begin if you were the lawyers here, taking charge of this case? What would you be focusing on to try to prove conspiracy to restrict trading?
Right. So that's the interesting thing. So, this part, remember, litigation starts by the filing of a summons and complaint, right? The complaint sets forth allegations. Allegations, generally, in a case, when you set forth your allegations, you are setting forth your allegations just based upon, just their allegations. They're literally just statements that are broken down paragraph by paragraph in a complaint that are unsupported. They're not supported. You don't need any proof at this point in a litigation. You have to be able to just, set forth enough facts, and not even facts. Like I said, they're not always facts. Facts infers that they're actually true statements. These are allegations. So you just have to set forth allegations that there was a conversation between Robinhood and Citadel, that there was an agreement between the two of them, and that agreement limited trade. So the interesting thing is, in this case, the defense is arguing, and they're making it seem like it's such a big deal, but it's really not. It's a lot of smoke and mirrors. They keep alleging in their motion practice that, the plaintiffs in this case had 10,000 pages of documents to review. And even with all those documents, their case is very thin. But the courts can't look at it from that perspective. Because in reality, when you file a summons and complaint and any action, no plaintiff usually has any discovery. There's usually no documents. It's just based on allegations. So you don't need to prove anything at this stage. This is a non-proving stage. And the reason why is because, again, like I said, this is a circumstance where they happen to have some documents due to the subpoenas from the government hearings. But the court can say, well, because in this case they had those documents, they get a different standard. The standard is still the same as if they had no documents. So they keep harping on that, but that is not, it doesn't mean anything. It means nothing. The motion to dismiss, which is what is currently pending in the court on the antitrust, is what's called a pre-answer motion to dismiss. Usually after someone submits a complaint, the other side submits an answer, which is basically they just deny all the allegations in the complaint. But before you do that, there's a list of like 7 ways that you can move to dismiss a case before you get to the answer phase. And one of them is failure to state a cause of action, meaning the court will look at the complaint and all the allegations as true. They have to look at them as true. There's an assumption that they're true. And even if they're all true, not proven, but just an assumption that they're true, then is there enough that in the next stage of litigation, they'll be able to prove that there was a conspiracy? So it's a really high standard. It's not to get a case dismissed is not easy. This is a very difficult part, and the reason why. So let me just go back and answer your question. So basically, I agree with the way they're handling this case. Everything is being handled. The way they're doing it right now is the way to do it. They have no other way to do it other than set forth the allegations as they understand them to be. So, they were fortunate enough to have some proof through evidence from the hearings, but usually don't have that. So I think what they're doing right now and their allegations are great. And, in terms of proving the case, and what you need to do to establish it, at the next stage in the litigation, at the next stage, then it becomes the onus falls on the plaintiff. The plaintiff is then the one with the hardest part now, because that means you have to prove your case. Allegations are one thing. Anyone can set forth allegations. Like I said, they can be unsubstantiated allegations. They're just set forth in a complaint. As long as those allegations meet the requirements of establishing an agreement to restrict trade, which I think they do based upon my reading of the complaint, then that's good. You've successfully achieved step one. But then step two, now it's time to prove it. And that's why surviving the motion to dismiss is so important. Because after you survive the motion to dismiss, they have to put in their answer. And then after they put in their answer, discovery starts. And what discovery is the opportunity for both sides and in this case, primarily the plaintiff. The defendant's not going to have really much in the way of discovery requests in this case. But the plaintiffs are going to ask questions. There's different types of discovery. There's interrogatories, which are basically questions on paper that are submitted to the other side that they have to answer. There's documentary evidence, which would be requesting, emails, internal files, et cetera, and so forth. And then there's depositions, which are oral testimony. So you bring in Ken Griffin, you bring in Vlad, you bring in the higher ups and the executives in all these companies, and you get to conduct and ask them questions. And that's how you prove your case. Nothing can be proven until the discovery stage. You can't get proof out of thin air. So that's why it's so important for them to survive this motion. If they survive this motion, then things are going to get really interesting. Now, that's not to say that, again, the key in litigation is to delay, right? Delay. That's the key. So you filed the motion to dismiss. All right, you lost the motion to dismiss. All right, well, what are you going to do now? You're going to appeal the motion to dismiss. Either side, right? Then the question is, does the court stay discovery, which means discovery won't happen until after the appeal is decided? That's a question that the judge will have to decide, and it depends on which judge you get. You never know what you're going to get with a judge. Some will stay discovery pending appeal. Some won't stay discovery pending appeal. Then let's say discovery moves forward. All right, they submit the discovery requests. Guess what the defendant's going to do? They're going to object to all the discovery requests, and they're going to file a motion to say, no, we're not answering these questions. You're on a fishing expedition. So it can go, that's why it can drag on and on for months. So think about it. This was filed back in April, right? Mm-hmm. We're in October.
Yeah.
The motion to dismiss was just fully submitted, right? And that's going to be about 60 to 90 days. So we're already going to be pushing into the holidays. Then once the holidays start, they're going to file the appeal. Either side's going to file an appeal, no matter what. And then you got to wait for a decision on the appeal, and that's going to take at least 6 months to a year. And then the question is, then the discovery motion. So that's right. So listen, this litigation will go on for years. This is going to take minimum 3 to 5 years. That's just the nature of the justice system. It's slow.
Yeah. And
not only slow, but the lawyers know how to, drag these things out. You file your motion, then you ask for an extension on time to put more stuff in. And then every 30 days, it doesn't seem like much in the short term, but if you add 30 days over the course of a year and a half, you're extending it in almost a whole year just from those requests for extensions. So, that's all part of the litigation strategy. So that's why, this thing will go on for a long time. Surviving the motion to dismiss is great, and that'll get your foot in the door. But once your foot's in the door, it's going to take a while to get your leg in.
Okay. So I just want to kind of go over and summarize just a couple of things you've said and clarify a few things that I just want to make sure I've got right here. So the process that we're looking at is they have to So we've got this is the motion to dismiss. So we're going to decide if that's happening or not. Then there's potentially, or quite probably in your mind, going to be an appeal to that motion to dismiss if it's successful or not. Although you seem to think that it probably shouldn't be successful because all it is allegations, and at this stage, any evidence that they have is out of the norm. It's not usual to have evidence presented at this point, even though they have. I guess is that like a fair assessment of what you meant on that side of things?
No. Well, no. I mean, I think it favors the plaintiffs. The plaintiffs. At this point in the litigation, everything is looked at in the light most favorable to the plaintiffs.
Yeah.
So the defendants have to really show that remember, the allegations are assumed to be true. So they have to argue that even though they are true, they still don't establish the elements of a conspiracy.
Okay. So
the defendant, if the defendant loses, right, that means the case can go forward. If the defendant wins, that means the case can't go forward.
Okay.
Now, no matter what happens, no matter which side wins, they're going to appeal.
Okay. So then we have appeal, and then we will have the answer to the lawsuit, at which point you can move on to discovery, and they can start requesting documents and summoning people in for depositions. So when we get to that point to discovery, when they request documents, is it do they have to know exactly which documents they're looking for? And do they have like any legal power to compel Citadel or Robinhood or whoever it is that they're requesting documents for to provide those documents, or is it like a discretionary thing?
So the standard for discovery is material and necessary. So the documentation that you're asking for has to be material and necessary to prove your case. So if they said, for example, we need to see the emails from Robinhood and Citadel between the dates of January 1st and January 31st, to establish the conspiracy. That I would argue would be material and necessary. But let's say, just as an example to show you what wouldn't be material and necessary, what would be deemed what the other side would call a fishing expedition. We want to see the emails for the last year and a half. Prior year and a half, from all emails from 2019 to 2021. Now, the judge might say, well, that's too broad of a brush, too broad of a stroke. You don't need emails going back 2 years. You're going on a fishing expedition. You're trying to find more than you need. It's discretionary, like you said, Josh. That's true. It's ultimately it'll be up to the judge. I mean, look, there's case law, that the judge and the attorneys will cite to support why they believe they're entitled to XYZ discovery. But again, in this type of case, the discovery is going to be substantial. Obviously it's going to be, at this point, they only have 10,000 pages. And a note about discovery. They keep saying, 10,000 pages of discovery, 10,000 pages of discovery. The reality is, when you get served with discovery, when they'll drop, I don't know if you ever seen it maybe in movies, but there's these scenes where there's these mass litigation, and then there's a scene where like they're loading trucks with documents, bins and bins and bins. And that's done partially on purpose, because it's like, okay, here's all the discovery. Good luck finding a needle in a haystack. They want to frustrate you or have you miss something. Think about it. If they, out of 100,000 pages, maybe only 5 of those pages actually have the smoking gun or the document that you really need, but they're going to make you work for it. Think about it. Think about what they had in their complaint. They said they went through 10,000 pages of documents, but how many of those actual pages were in the complaint that established, the possibility of there being an agreement? There was like 3 pieces of paper, and I'm sure they were stuck, way deep in the middle somewhere. They're not handing it to you in sequential order,
Definitely not.
So
I mean, so I'm curious actually, just on the subject of emails, say they requested that they said, right, okay, we want all the emails between the 1st of January 2021 and the 31st of January 2021. And Citadel were like, well, we don't have them anymore. Is there like any precedent to, I don't know, seize computers, or is there like a way to compel them to hand over whatever they might have? Like do they have, like, could they have just like burned the servers and deleted the emails, and like would that be enough to protect them at this point? Like will they just like get away with it like Hillary style? Or
Yeah, I mean, look, Josh, I mean, not to use the word conspiracy in the other sense, but yeah, I mean, look, there's always potential for shenanigans. I mean, for that to happen. But then, but if you get into all that type of stuff where there's a possibility that, did they scrub the servers? Did they, delete the emails? Okay, so then there's a couple of things that can be argued under that, right? There's what's called an adverse inference. So that basically says, well, the emails don't exist anymore. So the court can take what's called an adverse inference, which means, well, we can infer that the fact that those emails don't exist anymore, that there's something adverse, and there was a reason why those emails don't exist anymore. Now that's not a strong, adverse inferences aren't really that strong because it's still based on a lot of speculation, obviously, and that's not going to win you a case. I don't look historically when you look at big cases, you rarely hear situations like the Hillary situation where, parties don't come forward with evidence and, they try to hide it or obstruct, justice or anything like that. I mean, that's like high government, conspiracy, type of stuff. I don't think that happens on a daily basis. I'm sure people will disagree with me on that and say that it happens all the time. Judges are in people's pockets. In my experience, I haven't seen that. I just haven't seen it. So I'm not going to say that something is true just, because that's what people think. I mean, I've been doing this professionally for a long time, and I've never felt that any decision against me was made because, someone was in somebody's pocket. That's just not something that I've seen in practice.
Okay. So I'm curious as to whether you're aware of any like legal precedent or like cases upon which we can look back in this sort of like antitrust case where like conspiracy to fix prices has been alleged. Like, is this like a brand new sort of thing in terms of like what has been taken to court before? Like, obviously there's like allegations that fly around that hedge funds are manipulating prices all the time, but is there times when these sorts of firms have been taken to court in the past over things like this?
No, this is a very particular set of facts. This is not, this is unprecedented, and it's unprecedented to the effect that no brokerage has ever fully taken away the buy button from retail investors before. Right? There's no precedent for it. So that when there's no precedent, right, this is what would be considered or called a case of first impression, right? But it's really not, because conspiracy isn't new, right? Conspiracy cases exist for the last, 50 years or more, right? There's always been people conspiring against other people to, get money, to take money out of people's hands.
Yeah.
So from the legal perspective of conspiracy, this is not a case of first impression. But from the factual aspect of the case, it's first impression, because this has never been done before. Everyone keeps using the word unprecedented, and that's true. This is unprecedented. So basically, when you have that situation where it's unprecedented, you have to, use analogies, right? You have to find cases that are analogous, to this. And there's tons of them. I'm not going to get into them because they're so filled with like, over the top legalese that, your head would explode. I don't even like reading them. Constitutional law cases it's the class in law school that nobody wanted to take, because it's just the decisions are like over 100 pages long. They're dry as can be. And, they're so dense, that it really requires a level of focus that, it's hard to summarize. So that's why I try to just say, listen, there's case law always, for the most part, supporting both sides to an argument, right? That's the legal system.
Yeah.
The law says X, Y, and Z, right? Basically, this is how they teach you in law school, how to figure out how cases are decided, right? They call it the IRAC system. It's issue, rule, application, conclusion. So basically, that's, for the rest of a lawyer's life, that's basically, in a nutshell, what you try to do. What's the issue? Okay, the issue is there is a conspiracy between Robinhood and Citadel to take money out of the hands of investors by taking away the buy button so the price of the stock can go down so Citadel can cover their short positions, right? With not cover, but so Citadel won't get burned by their short positions. All right, so that's the issue. The rule is, in order to prove a conspiracy, you have to show X, Y, Z. The application of the rule. Based on these facts, we cite to this case, and this case. We cite to Twombly. We cite to various other cases that are out there from the highest courts possible. Remember, the higher level court, the more required the courts are to follow it, right? So there's two different types of case law. There's case law that's from the higher courts, which the courts have to follow, right? Yeah. And then there's there's lower court cases, and those cannot be taken at full value. They're called persuasive. So there's no mandatory requirement that they're followed by the courts. They're just persuasive. So, and then once you apply those laws, then they come to a conclusion. And remember, the person who comes to the conclusion in this case is the judge. Yeah. So it really just depends on how do these other cases that are analogous to this set of facts fall, in favor of who? And that's really what it boils down to. But there's so many levels, even after, like I said, after discovery, while discovery is going on, there's still another layer of motion practice that gets done. So, I mean, the litigation process takes a really long time to get to the actual trial part, which most of the time never happens, because while all this is going on, all this back and forth with the motions and the arguments, someone behind the scenes is trying to settle this thing.
Yeah. I mean, your talk about constitutional law classes there just like sent me way back to when I was in university, and we were studying European law, and we had to do cases like factor term, and oh my dear goodness, it was just reams and reams and reams of pages. And then the year after I finished, 1/3 of my degree was wiped out by Brexit. I don't need to understand European law anymore. But so I sympathize with people who with not wanting to go deep into the complexities of constitutional law cases. That's never really where you want to go if you want to keep things at least brief or entertaining.
Yeah, well, that's the thing with this case. I mean, this case is, all the cases are from con law cases. These are all Supreme Court cases that they're relying upon. They're all the attorneys are citing to various higher court cases, at the Supreme Court level. And that's the interesting thing too, Josh, about the appeal, to go back to that for 1 second. Remember, so this is right now in the lower court, right? This is the lower district court where the case is filed. Okay, so then that gets appealed to the next level, right? The United States Court of Appeals, right? Then after that, that's not the last appeal. They can still appeal yet again. Remember, you have multiple levels of appeals. So you have, after that, then you can ask for certiorari to the Supreme Court. And then if cert is granted, then you got to wait for the Supreme Court to make a decision. So when I said that this case can be appealed, that appeal could, think about it. The first level of appeal alone can take a year. Then the next level of appeal can take another year. And then for it to get to the Supreme Court, forget about it. These things don't happen overnight. So that's the other thing. I mean, that all goes back to the whole delay thing.
Yeah. It's obviously like legal cases take a long time. So anyone who's thinking this is going to be a quick wrap up is mistaken. Like the court case is not going to trigger the MOAS people. Registering with computer share is far more likely to do that. But so what did what are Citadel have what is the argument or that Citadel and Robinhood have come back with in this motion to dismiss? Like, what is the case they're making? Are they just they're literally just saying this is ridiculous, go away, you need more evidence? Is that like their argument basically? Would you ever expect them to not do that if they're, you know, I'm sure they have like Mr. Burns style, like they're 12 high-paid lawyers in the cupboard ready to come out and, you know, jump on Lionel Hutz whenever he comes with Homer. But like, is there ever a case in which they'll just say, no, let's just move along to the case and then we'll beat them in court? Or are they always just trying to frustrate the process?
No, I mean, no. In general litigation practice, this is standard. This is standard protocol. You know, the complaint gets filed. You file the motion to dismiss. If you're a lawyer and you don't file a motion to dismiss for failure to state a cause of action, you're committing malpractice. I mean, I mean, look, at the end of the day, yes, are the lawyers doing it so they get paid? Of course, obviously. But, you know, they got to get their billables. That's fine. But the flip side of that is, you know, if you advise your client, you know, you have to do this motion to dismiss, and they say no, okay, well, that's on them. At least, you know, if you're a lawyer and you don't file the motion to dismiss, and your client said, and it was because your client said no, I don't want to spend the money. Well, that's a foolish move on their part. You should always try to get the case dismissed, and most people do. You rarely see a situation where people just, you know, cut to the discovery phase. Again, and the reason for that is the delay, right? Delay the case as much as possible, because ultimately, if you lose that motion to dismiss, yes, you're going to file an appeal, but in the back of your mind, right off the rip, the next thing in your mind is, how are we going to settle this thing? I mean, that's just the reality. That's it. Surviving the motion to dismiss is great, but at the end of the day, the lawyers on both sides are going to try to settle this thing. It's unreasonable to think that they're going to take this all the way. And that's just not practical. It's not going to happen. It could happen. I mean, but if you think about it in terms of litigation and prosecution, right? Whether it's criminal law or civil law, 95% of cases are resolved prior to trial, either in a plea bargain or in a settlement. So, you know, the system is not set up for these cases to go all the way. People don't want to spend that much money. Yeah. So that's that. The court
system couldn't handle that many cases, really.
Court system can't handle what they have now. Yeah. You know, so I mean, the backlogs are ridiculous. And after COVID, and even now during still COVID, with everything, you know, they're getting their feet back underneath them. But there was a year where they didn't do jury trials. I mean, and at that point, that was a full delay for a year. Nobody did anything. Everyone sat on their hands and was like, well, no court system. I don't got to do anything. We'll wait it out. You know, if you're a defendant, you're not going to settle. I'll sit on my money for another year. You know, that's just the thing. So, okay. So back to what you had said about, you know, what their argument is. So remember, so conspiracy, right? How do you prove it? So at this point, they don't have to prove anything. That's the important thing. No proving has to be established. You don't have to prove anything. Right now, you just have to allege enough facts that in the next stage, you'll then have to prove it. So they're saying that at this stage, no, you have not set forth enough facts for this to be true, even assuming it is true. So there's two different types of conspiracy. There's direct evidence, right? There's a direct evidence case. That means there's enough proof at the pleading stage that there was an actual conversation between the parties and an agreement, right? That's called per se conspiracy. Then there's a second type. That's the circumstantial case. And circumstantial means you don't have any direct evidence. There's a bunch of other evidence. And when you look at that evidence in totality, it could mean that there was a possibility of an agreement between the parties. So they're saying not only is there no direct evidence, but there's also no circumstantial evidence in the complaint, which is complete nonsense. There is direct evidence. There's emails and correspondence between Citadel and Robinhood. Now, their argument to that is, yes, there were conversations, but the conversations that we had have a plausible explanation. And the plausible explanation isn't that we were conspiring with each other, the plausible explanation is that this was regular, ordinary course of business. There was an external stimuli, the $3 billion owed, that required these conversations to take place. And because of that, that's why we did what we did. Their other interesting argument is that, well, you're saying that Robinhood completely took away the buy button. But your allegation in your complaint is that we not only conspired with Robinhood, but we also conspired with all these other brokerages. Remember, they didn't only name Robinhood. They named Robinhood, E-Trade, Webull, and a bunch of other brokerages. And their argument is, right, their argument is for that, because they did that, their argument, and the other thing is they had filed it against a number of other brokerages as well, and they already cut them loose. They released them from the lawsuit, the plaintiffs.
Okay. Would you think that is that just for ease of is it because it's easier to prove this one specific thing rather than go so broad based?
They must have not had enough even allegations against the other companies and they probably said to themselves, well, these are probably not going to survive a motion to dismiss, and maybe it's going to confuse things further. So maybe they just got rid of them for that reason.
Okay.
That was a legal strategy decision. And that would be my guess. But their argument is, well, you're saying that there was a conspiracy, that, we basically told all these brokerages to stop, put limits, right? But they're saying if that's true, wouldn't the limits have all been the same? Why wouldn't, if we wanted to really, survive this, wouldn't we have told all the brokerages, listen, we want you to take away the buy button? But not all of them did that. Only Robinhood took away the buy button, right? E-Trade did some limitations on trading, and every brokerage did something different. So their argument is, well, everybody did something different, so therefore there can't be a conspiracy. They're saying it has to be identical. But the case law actually doesn't say identical. It says substantially similar. So basically, look, okay, listen, we're all going to get together and have a conversation. This is what we want you to do. Robinhood says, listen, you got it, boss. I'm going to do it. You're my payday. I'm going to do it.
Yeah.
You're 60% of my, your daddy, right? Yeah, that's it. I'm going to, the allegation is, you're my payday. So you know what? I'm going to do it all for you. I'm taking away that buy button. E-Trade says, listen, yeah, you guys are good for us, but we're not doing that. We're not taking away the buy button. We'll do a little bit of a limitation, a couple of days, whatever. So the argument for the plaintiff side is, listen, they don't have to all be the same. They all did a little bit of something to participate. They all did their part at the behest of Citadel. So that's really, what the argument is. They're saying, one side says that it has to be identical to show conspiracy and an agreement. Plaintiffs are saying, no, it doesn't have to be identical. It just has to be substantial. So that's on direct. So direct case, they're saying, look, this is clear as day. This is it. There was an agreement. We have proof through emails. And even if we didn't have proof through emails, because we don't need proof through emails, we just have to allege at this point that there was the possibility of an agreement between the parties. And remember, the key word is plausibility. Twombly, Bellowens versus Twombly, that case where a motion to dismiss was granted against the plaintiffs. They said that there was no plausibility. There was the more logical, plausible explanation was that they did it for business reasons as opposed to conspiratorial reasons. So that's really what it's going to come down to. Will the court find that whose argument is more plausible? We had no choice because of the money we needed to come up with, or is the more plausible the agreement between the parties? That's really what it'll boil down to.
what is your sense? Just like from a purely sort of, yeah, from a legal standpoint, like take your heart out of it for a second, because I sometimes I have to try and do that when I'm talking about this sort of stuff, because like sometimes I'll be talking to somebody and be like, when the MOAS happens, and I'm like, I can't say when to everyone. Not everyone's that bought into this idea. So like, what do you think? Do you think they have a case? Do you think this is like plausible based on what they're presenting?
Yeah, I mean, look, any type of case at this point is, like I said, it's looked at in the light most favorable to the plaintiff. But if you look at the case law, you would think otherwise, right? You would think that there would be a lot of there. Look, obviously, there's more victories than there are defeats at the motion to dismiss stage. So they're really hard to predict. But I think if based on what they have in their complaint right now, I really do believe that there is some level of direct evidence. I think that they do have a direct evidence case. I think they were lucky in that regard to be able to establish that through some of the documentation, even though they didn't need it. But again, you're talking about a subjective, right, opinion, because it's based on law, yes, but it's also based on facts, and everyone interprets facts differently, right? And the judge is the fact finder. So it depends. So from me, my definition of what's plausible is different than another person's definition of what's plausible, right? So if you look at the way they paint the picture, the defense paints it as, we had no choice. But if you really dig deep into the evidence, is it true that they didn't have a choice? Because in reality, they negotiated it down to 1.3 billion, right? It wasn't 3 billion. They had the money at that point. There was no concern about covering it, right? That's the allegation. They could have kept going forward.
Yeah. I think just for posterity, like I'm pretty sure Vlad said that they negotiated it down to 700 million, actually even further from there.
Right. And yes, well, that makes it even stronger of a case, right? So they negotiated it down. They had the money, and since they had the money, then okay, if you took the buy button away for 1 or 2 days, okay, maybe that's plausible. But they took the buy button away for a long time. This was not something that lasted a few days. This lasted a long time. So the plausibility, for me, goes out the window the longer it took. You know what I mean? It almost seems like, okay, yeah, look, can things go wrong? Absolutely. Will mistakes be made? Yes. Will there be a need for pullbacks based on, look, their terms of service say they don't guarantee uninterrupted service, right?
Yeah.
That's a whole other issue. That's on the negligence case. But again, you're talking about a situation where this was dragged on for a really long time. The other brokerages, allowed people to buy the stock much quicker than Robinhood. So the question is, again, that goes back to the other argument. Why did Robinhood do this longer than everybody else? Their argument would be, we had no choice. And then the other side's argument is, no, that's not what happened. The other players did their part and they were done with it as far as they were concerned. But you kept it going because you had to keep, feeding your boss. And that's what their allegation is. There's no, again, at this stage in the process, there's nothing that needs to be quote unquote proven. You just need to set forth enough allegations to meet that a judge might believe you'll be able to meet the elements. But I think that's where it's going to come down to. The judge is either going to say, you guys are wearing tinfoil hats. This is not a plausible argument. The more plausible argument is, listen, Robinhood had its back against the wall. They had no choice in the matter, and they pulled the buy button, and it was within their rights. And if there's any issue with that, take it up with the SEC. Yeah. That's one way it could go, right? The other way it can go is the judge says, yes, on its face, the defense makes an argument that seems to present a plausible explanation. But if you dig beneath the surface and we can do a little more discovery, I think we'll be able to find that there might be something here. So that's basically the two possibilities. I think, honestly, I think for this case, there's a strong possibility that, there's enough there to get to the next stage in the litigation. I think there is.
Okay. So I am rapidly running out of time here, unfortunately. I have to go and finish more filming for the documentary I'm appearing in about GameStop and short selling. So it is a worthy cause for which I'm going to abandon you. But there are just a couple of rapid fire questions, basically, that I wanted to put to you. So first up, some of these are to do with the case, some are not. So
Sure.
Has Kenny committed perjury in Congress when he was testifying and saying that there was no communication and there was no sort of collusion between them? Do you get the sense that that's perjury, or is that just like people being hyperbolic?
Allegedly.
Allegedly. Okay, that's a solid answer. Do you see the possibility that more leaks will come from inside Citadel or inside Robinhood, or do you think we've seen what leaks that we might?
Well, I mean, I know we're short on time, so I'm not going to go crazy on this, but that's a word that drives me crazy, because I know a lot of the documents that were floating around on Twitter were called leaks, but every one of those documents was part of the case file. So they really weren't leaked documents. I think that's important.
Okay, so it's not like they've not been acquired through improper practices. I guess is what you're trying to say. Yeah.
Well, those documents were part of the 10,000 pages of subpoenaed documents, and they were all part of they're all part of the complaint, and that's all public record. So there's no leak from either side at the moment. The only leak is the Citadel Twitter feed, which is, as a lawyer, that baffles me. You have ongoing litigation, and you have, someone operating that Twitter feed making comments about ongoing litigation. Either the lawyers want to pull their hair out, and they're being ignored, or they're committing malpractice. I don't know which one it is.
I would say what's happened is the PR folks are in charge of the Twitter feed, and the lawyers are not being consulted, because no lawyer that I know would ever consider that to be a good idea. Like, those are not the actions of... Yeah. Anyway, last thing I want to ask is, what if Citadel and Robinhood no longer exist as companies by the time this goes to court? Does it just sort of disappear?
Well, there's an old adage: you can't draw blood from a stone. If a company is completely insolvent and there's no money to be won. But listen, when it comes to bankrupt companies, this is a whole other topic, but companies that go bankrupt in the process of litigation, like the Boy Scouts of America, for example, there's a litigation against them in an MDL against the Boy Scouts for certain allegations that were made against them. And basically, they're a bankrupt. They filed for bankruptcy, but as part of the bankruptcy proceeding, some of the money is being set aside to pay any potential settlement that might come from the case. So there is a possibility for even an insolvent, quote unquote, insolvent company during their bankruptcy proceeding for money to be set aside to pay for litigation.
Okay. Well, if anyone from Citadel is listening and the company goes bankrupt and you're out of a job, grab anything you can, and I am sure that you will be rewarded. Oh, that's a joke. Don't actually, take that as serious advice. Anyone who's listening, that's not, don't steal intellectual property, basically, is what I'm saying. Unless you want to, and it's your decision. Anyway, I really, really want to thank you for your time, man. It's been really educational and yeah, a lot of fun to be able to chat to you and get a better understanding of what we can expect and what to look for this case. So yeah, thank you very much, man. And do you want to point people towards anything before we wrap up here?
Yeah, thanks a lot, Josh. I had a great time. It was awesome. As the litigation progresses, if you ever want to have me back on, I would love to talk about the case in more detail. It's a lot of fun. And there's also a bunch of other legal topics out there now that are really interesting. I saw someone was posting that they were banned or blocked by Gary Gensler on their Twitter feed. That's an interesting topic to talk about because there's a whole line of cases that say government officials and government agencies can't block you on Twitter. So that's fascinating. The Ripple lawsuit is also interesting, where they allowed the Ripple owners to now act as file an amicus brief, which is really, really cool and interesting. And I think that's something to consider as this short squeeze litigation presses on. So you guys can follow me, though, on Twitter at Lawyer of the Apes and also on YouTube at Lawyer of the Apes.
Awesome. Well, thanks very much, man. It's been a pleasure. And thanks, everyone, for tuning in. Don't forget to share this with other apes. Hopefully people have found it useful. So yeah, thanks everyone, and see you soon.